Good afternoon. This is the Supreme Court of the United Kingdom. We are continuing hearing the appeal by Okpabi and Royal Dutch Shell Plc. Lord Goldsmith QC is presenting the submissions for the respondent. Lord Goldsmith.
My lords, I'm glad that we may have fixed the technical problems that bedeviled the end of this morning's session. I want to start by making one point which, whilst not strictly the focus of the appeal, is relevant when it comes to considering a number of the arguments raised against us. And that is that why we say that Nigeria and the Nigerian courts are the best place for adjudication of the underlying claims. That's not simply for the obvious facts that the claimants are Nigerian residents, SPDC is a Nigerian company, and all the alleged damage occurred in Nigeria, but also because they concern uniquely Nigerian problems of oil theft and illegal refining in what is considered to be one of the most dangerous areas in the world. Now, it's uncontroversial that the area in question is beset by what Mr. Justice Fraser described as oil pipeline sabotage, bunkering, and illegal crude oil refining activities. That's paragraph 15 of his judgment. The problem of pollution caused by illegal refining and pipeline sabotage is generally acknowledged. And the appellants, I believe, accept the risk and prevalence of third-party interference. Now, this is a massive contributor to environmental degradation in the area. One witness estimates that 1.25 million barrels of waste oil were discharged into the environment in 2013 alone. And that's the statement of Mr. Lee, whose statement is to be found at Appendix 2.1, tab 116. That's page electronic bundle 3604. And I would ask my lords and my lady to read that statement, which covers a number of very relevant topics. But these pollution issues are compounded by the overall security situation in the area, which is dire. In recent years, SPDC employees and contractors have been kidnapped and killed. SPDC employees have frequently been denied access to spill sites by armed gangs and community members. And the area in question is also plagued by the growing phenomenon of oil terrorism, which involves attacks on pipelines and oil installations by militias and insurgent groups. And some of this goes back to events that my lords and my lady will well understand led to the Biafran War and the devastation that that created in Nigeria, and the problems of the conflict between North and South. So these are systemic issues which the local police and security forces have struggled to deal with for many years. And indeed, the security problems in the area are so severe that the Nigerian military is required to intervene, including, and we saw pictures of those at first instance, via airstrikes. And Mr. Lee's statement again deals with that, as does Mr. Okunbo, one of the witnesses that my learned friend invited your lordships and your ladies to read. And his statement is at tab 32, EF 1639. And another witness, Mr. Agon Wanwi, whose statement is at Appendix 2D, tab 46, pages 1415 to 1430, and that's electronic bundle 2087 and following. So that has two consequences. One is that the idea that all oil pollution in the area is solely caused by spills from SPDC's pipelines, or that SPDC is solely responsible for those spills, must be dismissed. Of course, there are other oil companies operating in the Delta as well. Even more far-fetched is the idea that RDS, operating from London, has responsibility for these complex and multifactorial problems with deep roots in the historic and societal problems in Nigeria, or how they can deal with them from a head office in London or something of that sort, when it requires intervention by the military to stop these things, if that can be done at all. So that's relevant when one looks to see what is it alleged that RDS has failed to do. Because at the end of the day, any negligence case doesn't just require imposition of a duty, it obviously also requires the demonstration that the duty was breached in a relevant respect. And that's an area you've heard really nothing about from Mr. Hunt. Now, let me move on then to the my lord.
Lord Goldsmith, is that in any way a consequence of the way the decision has emerged? As I understand it, there was an invitation to Mr. Justice Fraser to conduct a preliminary issue, not on the question of breach of duty, but of duty of care, which might be said to be an antecedent question, which then turned into what essentially was a form of summary judgment, or a conclusion equivalent to a form of defendant summary judgment on the duty of care issue, so that in a sense the parties haven't really got to arguing about breach yet.
Well, 2 points I'd like to make. One is, my lord is of course right, the parties haven't argued about breach. But what I do say is, when you're considering what is the duty that is said to be imposed, it is relevant to understand what it is said to have gone wrong. Because otherwise you can't identify it's a relevant duty.
Yes. Yes, thank you.
And so that's one point. The second point is just that it's convenient to deal with it now. We did offer to have the question of duty determined as a preliminary question. And the reason for that was because so much evidence has been put in and we could see what was going to be said. So we thought, well, we're not frightened of this, so why not have this as a preliminary issue? But our opponents strongly resisted it. It's fair to say that it came at quite a late stage. And the judge, therefore, didn't allow that to happen. So we ended up arguing on the basis that was already set down in the statements and so forth. My lord, if I may, can I turn then to the evidential basis for the assessment which the Court of Appeal made? Because they did assess thousands of pages of internal Shell documents, Shell Group reports and publications, a host of other reports, and over 30 different witness statements. Now, and of course, on that's common ground, that unless my learned friend can persuade the court that there was a serious error of law, that can't be revisited on the appeal. And our position is that there is no basis for such a re-evaluation. And we set out in Annex A to our printed case quite a detailed analysis of the evidence. It's still high level at certain points. And I don't want to repeat it, but I do want to touch on certain key internal Shell documents, two of which you were taken to, and one of which we say ought to be the most important in one sense of all, you were not taken to. Now, first of all, you were taken to the Shell Group Control Framework. That's to be found at tab 55 of Bundle 2E or Electronic Bundle 2237. And that, and your lordship's ladyship will have seen, that was discussed in great detail in the Court of Appeal, for example, by Lord Justice Simon at paragraph 41 of the judgment. Now, we accept it's a critical document because it sets the blueprint for the interaction between companies within the Shell Group. It's the master internal document, if you like, and all other documents and processes fall within its structure. And that's why the Court of Appeal recognized, and the reference is paragraph 41, that it's the single overall control framework that applies to all Shell companies. It outlines formally how RDS carries out its governance functions in relation to the Shell Group of companies. And the control framework set down the framework within which subsidiaries within the Shell Group interact with RDS and as between themselves. And the reporting lines internally and so forth fall within its framework. Now, the substance and analysis of the framework is set out in paragraph 6 to 13 of Annex A to our printed case. I don't propose to repeat that material. I obviously do respectfully invite the court to remind itself of that in due course. Now, what the appellants did, they adduced that document in order to show that RDS had, and again these words, a high level of control. That was their case. A high level of control, and it intervened in the business of its subsidiaries. And I give a reference, though there are others, to the appellant's skeleton argument on appeal, which is at paragraph 5A, appendix 2A, 3, tab 47, electronic bundle 719. 719. But after closely examining it, the majority of the Court of Appeal concluded that the control framework, and I quote, did not come close to supporting the sort of proximity between RDS and SPDC on the basis of which the court might find a duty of care to exist in favour of the claimants. And that's Lord Justice Simon at paragraph 126. And what they saw instead was a broad and general framework of high-level policies and procedures to ensure that the over 1,300 subsidiaries in the group have internal controls. And the word control that comes up so often is actually about that, primarily, internal controls within the individual companies. Obviously, it contained guidelines to minimize risk within the group. That's actually something which is mandated by UK regulatory requirements, the combined code, the Turnbull guidelines, and other corporate governance standards. They expressly mandate that parent companies should ensure that there are controls within their groups. But it's not control in the sense in which my Lord Briggs used it in Vedanta, but controls in the sense of internal systems to manage risk and comply with the law. And as the Court of Appeal noted, the Shell control framework showed evidence of a concern to ensure that there were internal controls, not to exercise control or otherwise intervene in the operation of the thousands of subsidiaries. That's that important statement by Lord Justice Simon, paragraph 125. And both Lord Justice Simon and the Chancellor found this type of setup was not surprising for a large multinational group. And I will show in a few moments that contrary to what Mr. Herman has said, the control framework doesn't evidence that RDS has a peculiar or unconventional or specially high level of control relationship with its subsidiaries. Quite the opposite. It's very normal. Let me then come to the second document, which is the HSSE and SP control framework. Now, it's perfectly correct that the claimants got disclosure of that in the Court of Appeal. It may be instructive to notice how we had disclosed 2 pages from it and attached them to a witness statement. They made a complaint in the Court of Appeal, but that's all they had. And one of their lordships, and eventually all of their lordships, said, well, you've had reference to a document in a witness statement, why don't you ask for the whole of it? And that's what happened. They did, and it was all disclosed. And I want to show your lordship, something about it in one moment, because it's not just a single document. It is, in fact, many documents, and they got all of them. It's worth noting that in the application that they then made for disclosure, the reference is Court of Appeal transcript, day 1, page 27, lines 13 to 22. I'll quote the relevant words so your lordships, my lady, don't need to turn it up. That's in the additional documents, tab 3, document 74, and that's electronic bundle 5743. So what they said, and I quote, was that the contents of those documents and the specificity of those documents may be highly germane to the question of control exercised by RDS over SPDC. So they actually got them after that application. And so the Court of Appeal had the opportunity to test that proposition, to test whether disclosure of further internal documents would produce a great assistance to the appellant's case. But actually it backfired, because the internal framework documents and the manuals that were disclosed actually showed that RDS did not exercise de facto control of SPDC. And I'll show my lords and my ladies. First of all, can I make good what I've said about it not being a single document? It's a collection of important documents. If one could look at electronic page 3191, which is bundle T, appendix 2G, tab 91 at page 2891. My lords and my lady will see a list of manuals. So it starts at 3191, and then it has a number of manuals referred to. On page 3192, there's the management system manual. On page 3193, there's the health manual, the process safety manual, the personal safety manual, the security manual, and over the page, the environment manual, the contractor manual, the projects manual, the transport manual, the social performance manual, product stewardship manual. If there was something in those documents which demonstrated that RDS had taken control of the relevant operation, that's where it would be, said the claimants. But it wasn't. And the Court of Appeal, the majority, were able carefully to examine this document and demonstrate that for themselves. There's reference to mandatory standards, but it's not enough, in my respectful submission, just to say something is mandatory. In order to get within the control test, you need to show not just that it's mandatory, but what it is mandating. And what it doesn't mandate is what you actually have to do. We put it broadly by saying it told you you had to have a system, you had to have plans, you had to have internal audits. It didn't tell you how to make a pipeline or things of that sort. That's the critical point. So can we, if I could take my lords, for example, to page 3326 of the electronic Bible. That shows procedures for tank cleaning in accordance with internationally recognized standards. Nothing magical about that international standards should be followed. And then at page 3396, there's the policy this is page 3024 of the document, says that, and it's item 11, is the example I'm giving, establish procedures to assess and document the risks for berthing and cargo transfer operations. Establish procedures. So essentially what these do is they impose or require that the companies should have procedures and plans. Of course, that's very similar to what UK corporate standards require. The companies should have plans or processes in order to achieve certain objectives, but it doesn't tell you what those plans are. It tells you should have them, and then you have to provide them for yourself. And of course, given that these are standards which are high level, they apply not just to SPDC, but as Mr. Herman showed, my lords and my lady, to all the companies within the Shell family, as it were. in over 70 jurisdictions under 70 different regulatory regimes. So it would be astonishing if, in fact, RDS from London said, this is exactly what you have to do. Over and above, you have to have a plan and a process for doing it, which will, what's more, will have to take account of local regulations and local requirements. Like, for example, in Nigeria, the special difficulties of dealing with the security situation and the wide-scale theft and pilfering and vandalism of the infrastructure. But let us then go to the third level, which is the most granular of all. This is the documents that Mr. Hermer did not take you to. He gave you a list of these documents saying, oh my goodness me, this must all tell us all that we need to know. But the one document he didn't take you to was the one that one might think is the most relevant. And that is in relation to pipeline integrity. So let's look at, these are called the DEPs, made that reference, or design engineering practices. They sit under the structure of the control framework and the HSSE control framework. The appellants assert that they, and I quote, provide further insight into the extent of the detailed control which the RDS board exerts over the subsidiaries' health, safety, and environmental practices. That's paragraph 75 of their printed case, page 247 of the electronic bundle. So crucially, these represent the appellant's highest case on the granularity of mandatory group standards and guidelines. But it's clear on examination that they don't provide evidence of the, quotes, high level of control or, quotes, intervention necessary to make out a duty of care. Now, the Court of Appeal did examine these documents. In fact, the court examined the DEP with specific relevance to this case, the DEP on pipeline integrity, but it did not change the court's conclusion regarding a lack of evidence of intervention and or control. Now, the court's analysis of the DEPs is set out in paragraphs 18 to 21 of Annex A of our printed case. I refer the court respectfully to that. I don't read it again. But I would want to take my lords and my lady to the very document. So Appendix 2F, tab 68, page 2650. So it starts at 2649. My lords and my lady will see it's called Pipeline Integrity, DEP 30, and then some other numbers to identify it. And I just take my lords and my lady to the preface. So the preface says, first of all, in the first paragraph, that they are based on the experience acquired during the involvement, during their involvement with the design, construction, operation, and maintenance of processing units and facilities. And they are supplemented with the experience of Shell operating units. The objective is to set the recommended standards for good design and engineering practice. And then this very important paragraph. The information set forth in these publications is provided to Shell companies for their consideration and decision to implement. This is of particular importance where DEPs may not cover every requirement or diversity of condition at each locality. The system of DEPs is expected to be sufficiently flexible to allow individual operating units to adapt the information set forth in DEPs to their own environment and requirements. And when my lords, my lady, managed to see the statement of Mr. Lee, Mr. Andy Lee, particularly at paragraph 41, page 3606, you will see why he says that in Nigeria there are special operating circumstances which need to be taken into account, like, for example, the bunkering problem. Now, this is a mandatory policy. That's the point. And I think Mr. Hermer showed you that certain notation is used to indicate what's mandatory. This is mandatory. But what's mandatory is not you do it this way, you do it that way. It's you must decide for yourselves how to do it, taking account of local conditions. And that cannot be, in my respectful submission, an example of RDS taking charge, intervening, or anything of that sort. And I hope my lords and my lady might feel encouraged by that, because the proposition that my learned friend has been putting, that two experienced judges in the Court of Appeal, the Chancellor and Lord Justice Simon, should have somehow gone off on some bizarre frolic of their own, saying that even those were mandatory, they didn't amount to control. It's because when you look at the documents and see what they're actually doing, you see that they're not doing that. I can give other examples of that. So if we can look at paragraph 3 on page 2659. This sets out the mandatory requirements in relation to organisation, responsibilities, resources, standards, and documents. And what it says is that company organisational structures vary considerably, but there are common elements required to assure effective pipeline asset integrity management. And then it sets out what they should be. Have a clearly designated single point responsible person. Second bullet point, have sufficient resources. Third point, human resources should be competent. Fourth point, they should have clear written responsibilities and have appropriate training. Fifth point, there should be a formally defined means of interface management between the various involved parties. Now that's not RDS taking control. It's laying down sensible requirements that there should be, namely that these are the things that should happen. But it can't be said it's intervening or taking control of the operations. And if they're not taking control of the operations, then at least I'll come back to what is termed route 4 of the matter. If they're not taking control of the operations, it's very hard to see on what basis they should be have a duty of care in respect of those operations. So, the Court of Appeal had that example. Can I take one more example, which is at page 2657? That's at paragraph 2.23d under emergency response. I think Mr. Herman might even have taken you to this. Well, not in this document, of course. I'm sorry. He took you to a similar statement in another document, but not to this document. And of course, the reason I say this is the most important DEP is because pipeline integrity must be the first place you start if what you're complaining about is that the pipelines leak. And what the DEP says is recognizing that it's not possible to foresee and prevent or mitigate every possible risk to a pipeline, plans shall be developed for an effective emergency response. Plans shall be developed. That's all. That's not taken. It's important. It's important, but that's not the same as RDS saying this is how thou shalt do it. So the Court of Appeal were therefore right, I would respectfully suggest, to say that these documents, and I'm quoting from paragraph 205 in the Chancellor's judgment, these documents provide no real evidence to show that these practices were imposed, even if they were described as mandatory, and do not indicate control. That control rested with SPDC, which was responsible for its own operations. As Lord Justice Simon said, RDS wanted to know that the subsidiaries had controls, but it wasn't taking control. And there's all the difference. So the majority haven't gone off their rockers by saying these don't actually impose requirements. They, having looked carefully at the documents, they recognised that they didn't do what was necessary to be done in order to give rise to an arguable duty of care. It goes one stage further, because once one's got these documents, why should there be anything else which goes further? You've got the lowest level of granularity, you've got the detailed constitution, you've got the framework, you've got all these manuals, however many it was, I said 7 of them. And Mr. Hermer cannot point to a single reference in them which shows something was done that was wrong. And that's why I said one does need to marry the duty of care up with what the alleged breach is. Not quite the same point, but it's relevant. My Lord Hodge put to Mr. Hermer, it's true, isn't it, that you haven't alleged any defect, any systemic defect? That is absolutely true. And I want to show your lordships at one point, if there's time, that was put to Mr. Hermer in the Court of Appeal, and he acknowledged he had none. He didn't even say on that occasion the point that he made to your lordships today, which is, oh, well, UNET report says there's something wrong with the remedial way of dealing with the soil when it's contaminated, which, by the way, has absolutely nothing to do with these spills, nothing to do with saying that there should have been a method for preventing sabotage, nothing to do with saying systemically they didn't actually require SPDC to have a system which would do that. All he's doing, and it's throughout this, is saying something might turn up. And unlike Vedanta, because of the volume of documents, and it doesn't matter how the claimants got them, they got them. They got lots of documents and they got lots of people telling them things as well. So they got a body of information. Actually, they could have done more, because we know, your lordships may not have picked this up, we know, for example, that SPDC has not been able to operate in Bilay for quite some time, and it's very difficult to operate in Oghali. So actually, it's the local people who've got much better access. So why aren't they saying, the claimants, well, we know that what went wrong was this? There are a couple of things said in one of Mr. Leader, who's one of the Leader partners, witness statements about things that might have been done. Remote control to watch pipelines, or encasing pipelines in concrete. These are dealt with in detail by one of our witnesses, Mr. Agnete, and he's a witness I would also ask my lords and my lady to read. The reference to that is at Appendix 2D, tab 45. Sorry, yes, electronic bundle, page 2074, and that's in paragraph 19. Well, that's one of the paragraphs. And Mr. Lee, similarly, and I've already referred to that, Mr. Agnete talks, he's the man who is responsible for dealing with pipeline integrity. You'll see his qualifications. And he explains what was done, that it had nothing to do with RDS, it's all SPDC who've got, and SPD is the ones who've got the expertise, because they've been dealing with this in Nigeria. They're not a cipher subsidiary, they're not just a post box. They've got all these resources, I'll come back to that in a moment, and they have investigated and researched all of this. They're the ones who produce the details. They cannot be dragged, my lords. I'm sorry, I sound like I'm shouting. I just want to make sure I'm heard this time. I apologize if it's abrasive, but they are being dragged into the English courts to investigate archetypally Nigerian questions with Nigerian witnesses looking at how to stop Nigerian sabotage, because something might turn up. That's it. And in the circumstances of this case, where so much material has been addressed. I know we're criticised, both parties were criticised by both the courts below for the amount of material. And I hazard a guess we may get criticised again. But the fact is, it's there. It's there and it was looked at. It was looked at by Mr. Justice Fraser, not all of it. It's looked at by the Court of Appeal. Nothing that they didn't look at has been identified. And that's why it's so wrong to try and embark on an exercise of re-evaluating all this and asking my lords and my lady to do that. So just to finish this part of it, so the overall picture that emerges from the evidence is this. First, the group standards and policies are abstract, generic structures and systems. They broadly provided guidance on what was good practice, but did not generally tell subsidiaries how to achieve the broad aim. Second, they were not detailed and granular. And the appellants were forced to abandon their speculative assertion once they were confronted with the documents in real life, in a real life disclosure exercise. Thirdly, the standards and policies are not compendious, detailed, or prescriptive as alleged. Rather, fourthly, they're a skeletal, high-level framework, largely reflecting industry standards that would be adopted in any event. Mr. Lee, para 41, that's page 3606. Mr. Agnetti, para 19, that's page 2074. And fifthly, the group standards merely set general goals. As Mr. Okonbo, the managing director of SPDC, explains, the standards are generally incapable of implementation in the form in which they're promulgated. They must be domesticated and implemented by each operating company as appropriate to local circumstances. They don't impose or prescribe how group companies should meet the broad and high-level objectives identified. That's unsurprising, given that these high-level and broad standards apply equally to all operating companies in over 70 jurisdictions. Mr. Hermer will probably try and find a place where in one of these documents the word how is used. But please, my lords, my lady, examine it carefully, because it'll turn out to be still another thing saying you should have something of this in place, not telling actually how it should be done. And although, sixth point, I think, although certain group policies are described as mandatory, it's clear this doesn't mean what the claimants want it to mean. They don't provide evidence of a high level of control and or intervention necessary to make that a duty. They don't answer the critical question that my Lord Briggs posed in Vedanta. As the Court of Appeal rightly noted, they provide, and I quote, no real evidence to show that practices were imposed, even if they were described as mandatory. They don't indicate control. That control rested with SPDC, which was responsible for its own operations. And that's why, after reviewing the evidence, the Chancellor at 205 said, RDS said there should be a system of supervision and oversight, but left it to SPDC to operate that system. And Lord Justice Simon said it wasn't that they wanted to control, but they wanted to see that there were controls. Paraphrased. Now, the appellants also point to the process of assurance and audit mentioned in the control framework, and assert that these must amount to control, indeed high level of control, says Mr. Herman. But the Court of Appeal looked at the evidence and concluded it did not. Lord Justice Simon at paragraphs 124 and 127, electronic bundle, page 476, said that the HSE and SP assurance indicates that the team would review the effectiveness of the control framework across all of the Shell Group's operations. But it doesn't indicate the exercise of any degree of control or amount of control. My lords, that's plainly right. And the Chancellor found that RDS said there should be a system of supervision and oversight, but left it to SPDC to operate that system. My lords, my lady, that's also unsurprising. The assurance and audit processes, which you can identify, they're largely self-assessment. The assurance letter that Mr. Herman made such a fuss about That's something which is supposed to tell the next level up whether they complied with the guidance. Not how, not setting them an examination paper. So a bit like an audit report says, did you examine this? Yes. Did you examine that? Yes. That doesn't amount to the sort of control that's necessary to say that RDS took control of the operations of SPDC. It's not intervention. It's not a system of intervention. It's not so we now know how to police things at night in the Niger Delta. Now, on SPDC itself, I mentioned a little bit, but can I just give a couple more references to this? I've said it's not a cipher company. It's a very substantial company in its own right, with many employees. That's Mr. Okunbo, paragraph 11. That's page 1622. Assets of $5 billion US. That's Mr. Okunbo at paragraph 14, page 1623. Pre-tax profits of $1.6 billion. That's his witness statement at 14, page 1623. Large budgets, he says. There are large budgets devoted to research and development. Paragraph 13, page 1623. Large technical departments, he says, and large numbers of personnel in the areas of oil spill remediation and prevention. That's Mr. Lee, paragraphs 9 and 40. That's pages 3221 and 3223, and pages 3593 and 3605. This is the detail of what actually happens on the ground. But all it demonstrates is that the Nigerian operations aren't run by SPDC, let alone RDS. Rather, they're operated, by a joint venture. This is a further point that I haven't made clear before. They're operated by a joint venture. Your Lordship, my lady, would have seen that in the evidence. It's a venture between SPDC and a number of oil companies, including NNPC, which is a government entity. And that's in Mr. Okonbo's first witness statement at paragraphs 22 to 30, page 1626 to 1628. And the JV, my lord.
You say it's a joint venture, but is SPDC not the operating company for the joint venture?
Yes, and I was going to say that now. But there is an operating committee. It's quite right that SPDC is the operator, but there's an operating committee which comprises all the JV partners. The governmental and that has the largest share in the JV, and as such has an effective control, along with other partners, with the government having veto rights. And Mr. Okonbo deals with that, paragraphs 26 to 27 of the witness statement. So if one got to the stage when it was being said, what went wrong with all this operation was you didn't have armed guards on every single visible piece of the pipeline, or you didn't bury the pipeline so far underground, that would have been something that the operating committee would have had to consider. So to say RDS controlled that is absurd, with respect. But the other point that's made clearly is that SPDC places no reliance on RDS to respond to oil spills, to carry out repairs, or to effect remediation. They're carried out, he says, entirely by my team. That's what Mr. Lee says, and implemented by SPDC. So that evidence of those three people, Okunbo, Lee, and Anyeti, is entirely consistent with what we saw in the control framework. I now want to contrast that, if I may, with Vedanta. And the facts, as the Court of Appeals saw them, and as I hope now my lords and lady are beginning to see, or have seen, are very, very different from the facts in Vedanta. Let me just remind the Court, if I may, of these facts. In Vedanta, the parent company had publicly undertaken to address the environmental risks and technical shortcomings in KCM's mining infrastructure. The Court will recall that Vedanta came in and took this over, and they made very clear public statements about what they were going to do. So if I can take my lords and my lady actually to the Court of Appeal judgment in our case, at paragraph 197. The Chancellor there dealt with some of the differences, and they're summarised there, including.
Could you give us the electronic bundle number?
Yes, I'm so sorry. 496.
Thank you.
496. So it's paragraph 197. And I'm not going to read it out. I will invite my lords to look at that, obviously, but also to perhaps the last two sentences. And I'm going to take my lords to actually what was said in the Longoe case in the Court of Appeal, where Lord Justice Simon dealt with this in a bit more detail. The witness evidence is on page 497. The witness evidence in Longoe and Vedanta specifically explained how the parent company had discarded the operational policies of the subsidiary and put in place its own policies and management. As we'll be seen, that was very much more specific than anything in the witness statements that the claimants could rely on here. Can I take my lords, my lady, to that? Vedanta in the Court of Appeal, get the electronic bundle reference. It's in tab 14, starting at electronic bundle, page 4040. And I want to take my lords and my ladies to paragraph 84, which should be at page 4057. At 4057, paragraph 84 in Lord Justice Simon's judgment sets out these factors. And I would invite the court to have regard to all of them. But can I just draw attention to some features? First of all, paragraph 3 identifies particularly the training that Vedanta put in place. Paragraph 2, the management and shareholders agreement that Vedanta reached. Paragraph 1, the report embedding sustainability, and which makes an express reference to the particular problem at the mine in Zambia. On the next page, there's reference to the financial support for KCM, and I'll come to that slightly later. But then the public statements, and given, if I may respectfully say so, what my Lord Briggs said in the Supreme Court about public statements, it's worth perhaps just looking at what they were. Various public statements regarding its commitment to address environmental risks and technical shortcomings. For example, a document which explains that most of the infrastructure that Vedanta acquired when it purchased KCM was old and in need of modernization. As a result, Vedanta inherited several legacies, including old tailings pipelines susceptible to frequent leaks. So that's the very problem that gave rise to the claim. In addition, it goes on, once Vedanta acquired KCM, we, i.e. Vedanta, immediately designed a comprehensive and well-funded program to address the legacy environmental issues. We particularly focused on the areas that most affected the surrounding communities when modernizing infrastructure to local and global industrial norms. It's hardly surprising that that sort of specific statement might raise the question, well, if you do that, if you say that, but fail to achieve it, do you have a responsibility? And then, very importantly, subparagraph 6, there was a KCM employee, a Mr. Davis Kagangila. He had been employed by KCM for over a decade, and he made a witness statement in which he gives evidence of the high degree of control Vedanta exercised over KCM's operational affairs, actually operated over those affairs, not just had the possibility, but operated over those affairs. He said, once Vedanta took over KCM, working practices changed significantly. It became clear that cost cutting was the supreme objective. This compromised other areas of work. Almost all senior positions were given to people from Vedanta. He adds that important sentence: when Vedanta took over, most of the existing management and operational policies were discarded or became irrelevant. Well, my lords, my lady, a very clear example of direct intervention in the operation. Not just saying to KCM, oh, by the way, you make sure you've got a plan for dealing with leaks. Actually taking over, discarding the previous policies and imposing new policies themselves. And so we submit that factually that's very different from the position that we have here. We do make the submission, I've already said it, that RDS cannot possibly deal with the problem of systemic pollution and criminality in the Niger Delta from afar, and nor has it committed to doing so. All that happens at the group level is that high-level group-wide standards are promulgated, which SPDC then implements itself in accordance with its own expertise and understanding of the situation on the ground, including the requirements of Nigerian law. And if that includes deciding that in the event of certain evidence being seen, they should call in the military, call in airstrikes, call in the police, that's what they will do. It's not a phone call from London that does that. Now, I've drawn attention to the fact that Vedanta, the parent company, also contractually, at least, provide technical services, including geographical and mining services. RDS doesn't provide SPDC with anything remotely similar. There's one other feature of Vedanta that I want to draw attention to because it's another distinction from the present case. In Vedanta, the subsidiary KCM was in a precarious financial position. And there was a risk that it would not be able to meet its liabilities to the claimants. SPDC, on the other hand, is a financially independent company. I've shown, my lords, my lady, the figures in relation to SPDC. And what's more, KCM was not part of a joint venture. It was 80% owned by Vedanta, which meant that Vedanta had full control over its mining operations. And you, my lords, my lady, have seen that Vedanta employees played a significant role in the operation of KCM. But can I just take, my lords and my lady, to what was said at first instance about the subsidiary and its financial position by Mr. Justice Coulson, as he then was. That is at electronic bundle page 4000. And there's a couple of passages I'd like to draw attention to. Paragraph 13 at page 4000, and then starting at paragraph 18 on page 4005, there are 2 points. I won't read it out, but invite my lords and my ladies' attention to it. He deals with 2 points. One, the dishonesty that had been found by other judges in relation to particular KCM employees who were relied upon in that case in any event. And secondly, at paragraph 22, paragraph 21 and 22, great worry about the financial position of KCM. And at paragraph 79, it goes even further than that, because at paragraph 79, Mr. Justice Coulson raised the possibility that the way that Vedanta was operating and working, it might actually allow KCM to go into liquidation, insolvent. Well, my lords, in looking at the internal controls, Mr. Hermer has emphasized what he says is the exceptional nature of the relationship between RDS and companies in the group, and suggested that this was exceptional. All the features, I'll deal with this quite shortly, I think, but all the features which he relies upon actually are nothing exceptional in the context of multinational companies. And one can see that, for example, from Unilever, the case in which my lords and my lady did not give permission to appeal. If we can see at paragraph 19 of the judgment in Unilever at electronic page 3656, sorry, my lords. You can see there at paragraph 19 that Unilever, paragraphs 18 and 19, discusses the Unilever structure. Again, I won't take the time to read this out, but the court will see that it was effectively run as a single economic entity with a group chief executive and an executive team known as EXCO or UX, responsible for the operational running of the Unilever group. There was one Unilever operating framework. There were group-wide policies imposed by the parent companies, which were both universally applicable and mandatory, paragraph 17 and 18. But so those paragraphs 17 and 18. If one looks at those and compares those with what's being said about the current case, one finds that Unilever is possibly even more controlled than SPDC. But these are standard practice for multinational groups, and it's therefore unsurprising that the Court of Appeal concluded that the claimants didn't meet the relevant threshold. And I can make that good shortly by reference to some other examples which my lords, my lady have in the bundle. At tab 818, document 55, document 55, it's called Additional Documents, tab 181. It's electronic bundle, page 5850. We see the BP annual report, and it has a discussion at page 5856 of the executive team. And I'd invite my lords and my lady just to look at what's said in the box on the left-hand side. It talks about the board and its committees. The second paragraph says the 6 board committees provide oversight. Safety, Ethics and Environment Assurance Committees looks at the processes. The next box talks about the executive team and its committees, what they do. Not different from what's being said in relation to Shell. There's a similar report in relation to Glencore, which is at 5879. And group policies are addressed there at 5876. And if one looks at page 5887, it can be clear that these corporate structures are in place in order to comply with UK regulatory requirements. give one more reference, the Chevron Corporate Responsibility Report, 2016, and that is at page 5867. Refers to the Chevron board, and the control framework mechanism at 5869. All of this gives the lie to the idea that Shell is exceptional. It's an extremely and unusually high level of control. Now, I want then to turn to the question of the so-called Vedanta routes. My Lord, I don't know whether at what point my Lord wants to break this afternoon, maybe not at all.
The latter, Lord, the latter. We won't have a break. Thank you very much.
Thank you, my Lord. Thank you. So, what's happened now is that the appellants, having failed, and we think knowing that they failed, to make good the case as they were putting it below, now rejig their case so as to take my Lord Briggs's observations in Vedanta and turn them into different routes of liability. But in reality, my lords, all of those routes were in fact considered by the lower courts. So the Court of Appeal addressed the claim that RDS had intervened in or otherwise taken control over the management of SPDC, and it found no arguable case. The Court of Appeal clearly addressed the question whether the appellants had made out a case of defective group policies, as my Lord Briggs referred to under the heading of published statements. Actually, I told my lords I would come back to this. The appellants were asked in the Court of Appeal whether they were advancing a case based on defective group policies. They confirmed they were not. Reference is to the exchange with Lord Justice Sales, transcript day 1, page 45, line 16 to 46, page 40. That's additional documents, tab 379, or electronic page 5748. In any event, the Court of Appeal did not find any evidence to that effect, nor any evidence to find that the relevant policies were followed by SPDC, as of course, using that language from my Lord Briggs. And that effectively dealt with and disposed of Route 2. The Court of Appeal expressly considered whether the group policies had been actively enforced by RDS. It concluded expressly there was no such enforcement. The evidence showed that SPDC did not rely in any significant way on these high-level standards, nor was there any enforcement training or implementation, as of course, by RDS. And, my lords, the Chancellor was plainly alive to this as a potential route to liability, because he said this at paragraph 205. He says the promulgation of group standards and practices is not enough to prove the imposition of mandatory design and engineering practices. There was no real evidence to show that these practices were imposed, even if they were described as mandatory. There would have needed to be evidence that RDS took upon itself the enforcement of the standards, which plainly it did not. It expected SPDC to apply the standards it set. That's plainly right, but if I may respectfully say so, it was the evaluation to which the majority of the Court of Appeal came, and that's enough for this court to say not appropriate to interfere. In relation to the appellant's Route 4, the Court of Appeal did examine published statements relied upon by the appellants and said to be attributable to RDS. It concluded that they didn't provide evidence of intervention or an assumption of responsibility. That deals with Route 4. And as I've said, the published statements of RDS are a very long way from the undertakings by the parent company in Vedanta. As I said, in Vedanta, the parent company specifically undertook to ensure that waterways were not contaminated by the mining operations in Zambia. And at page 4025, it said that that section of the report makes express reference to the particular problem at the mine in Zambia and states that we have a governance framework to ensure that surface and groundwork do not get contaminated by our operations. And that's not remotely like the situation in the present case. Well, my lords, in our printed case, paragraphs 107 to 160, we deal comprehensively and, in my respectful submission, convincingly with the demolition of each of the 4 routes that my learned friend puts forward. I don't have time to take my lords to it, but I do, of course, respectfully invite the court to look at that again, because it is an answer to this very critically important. Fundamentally, RDS couldn't in any way possibly have given a public undertaking of the sort that Vedanta gave. That would have been a public undertaking to prevent oil pollution or illegal sabotage in the Niger Delta. Given the situation on the ground, it couldn't possibly have given such an undertaking. But in any event, it didn't. Even the government of Nigeria has been trying unsuccessfully for years to deal with the problem. So we respectfully submit that a thorough evaluation by the Court of Appeal precludes any further arguments under that head. So I turn then to the alleged errors of law. The first is group-wide policies. The appellants allege that the Court of Appeal committed errors of law by taking an approach to the promulgation of group-wide policies which was inconsistent with what my Lord Briggs said in Vedanta. Now, we deal with this in our printed case at paragraphs 94 to 100. And I invite my Lord's attention to that. My Lord Briggs didn't hold that establishment of a group-wide policies necessarily gives rise to a duty of care on the part of the parent company, nor whether the existence of group-wide policies would carry weight in assessing questions of parent company liability. As we understand it, my Lord contemplated situations where group-wide policies do not of themselves give rise to such a duty of care to third party, which is what my Lord said in paragraph 53. And that's what Lord Justice Sales, that chimes with what Lord Justice Sales said in Unilever, where he held that the promulgation of mandatory group-wide Unilever policies didn't suffice to give rise to a duty of care in the circumstances. Paragraph 18 of Unilever. So neither Vedanta nor Unilever provide a basis for the appellant's suggestion the promulgation of group-wide policies is sufficient in itself to establish an arguable duty of care against the parent company. Such an interpretation would establish a presumption, a troublesome presumption, in favor of liability for the parent companies of most, if not all, multinational corporate groups. In any event, the appellants didn't plead a case based on, nor is there any evidence that RDS promulgated defective group-wide policies. And the most that the Court of Appeal did, we submit, is to hold that the type of group-wide, non-defective policies that it was dealing with would not generally suffice in and of itself to show a sufficient level of control or intervention. The Court of Appeal did acknowledge the potential for liability where a parent company requires subsidiaries to follow defective systems. That's paragraph 196. And the Court of Appeal did consider, paragraph 132, whether the appellants had made out on the evidence a properly arguable case that RDS assumed responsibility for devising a material policy, the adequacy of which is the subject of the claim. It is, standing back, still extraordinary that with all the time and all the resources that the claimants have had, all these witness statements, all the documents that they have had, all the opportunity to investigate, all the access to these places, that they haven't pointed to what the failing actually was. Not surprising, because if there were failings, they're not RDS's failings. No ground for imposing a duty on RDS. And as I was submitting when taking my lords and my lady through the actual documents, what must matter is what the policy actually is in any event. If what the policy is, you should have plans to deal with this, it's hard to see how that could ever give rise to a liability. And that's all that the Court of Appeal saw. All that the mandatory policies that Mr. Herman was pressing on them were really things along the lines of, you shall have a policy, you shall have a plan, you shall have an audit. Right, I'm being told I need to speak up slightly. My lords, my lady, can I just turn then on to McCall? The appellant's evidence has always been extremely thin. That's what Mr. Justice Fraser said. His assessment, paragraph 89, page 545. I'll just read it. The evidence on the part of the claimants is extremely thin, bordering on sketchy, in a great many instances simply not evidence at all. I take it at its highest for the claimants due to the early stage of the proceedings. Took that point in their favour. However, upon analysis, it can be seen that it's very strong on assertion and considerably weak on actual evidence. That was, in our respectful submission, a wholly accurate statement. And the Court of Appeal reached a similar conclusion, despite the fact that considerable additional evidence was adduced, including the extensive internal Shell documents obtained under CPR 31.14. As Lord Justice Simon said at paragraph 126, page 476, even putting it at its highest, the exiguous evidence of centralized assistance to SPDC in contradistinction to all operating companies does not come close to supporting the sort of proximity on the basis of which the court might find a duty of care to exist in favour of the claimants. So, my lords, the appellant's case against RDS is flawed. It's speculative, and it's still speculative. They've been driven to change it throughout. I could take my lords, my lady, through the changes, but I'm not sure there's time or need to do it. But the more evidence becomes available, the more they retreat from their previous assertion and come up with some different theory. And the fact that the disclosure that they've had, the documents they've got, further weakens rather than fortifies their case, is a very clear answer to the point about something may turn up in disclosure. As I've said, both the Court of Appeal and Mr. Justice Fraser clearly did consider the prospect of further evidence emerging on disclosure. It considered at length the possibility of RDS disclosing further internal documents. The relevant authorities are discussed and summarised by the Chancellor at paragraph 182. And he concluded at paragraph 198, I quote, I entirely agree with Lord Justice Simon when he says that the documentation relied upon by the claimants, and even the documentation that they can reasonably be expected to turn up on disclosure, seems to constitute high-level guidance based on centralised accumulation of a wide range of expertise, experience and best practice. It does not, however, indicate or even point towards either the exercise of any degree of control by RDS over the operations of SPDC or the assumption of responsibility. Now, it's clear that the Court of Appeal thought carefully about whether there were reasonable grounds for believing that further evidence would emerge on disclosure which would improve the appellant's case. But it reached the view that further disclosure would not alter the position. See, for example, what the Chancellor says about the application that was made to defer judgment so that the claimants could produce further documents which had come into their possession, a large number of further documents. We believe DEPs which had come into their possession. But they never made an application to introduce them. They haven't made an application to introduce them before your lordships in this court. One can safely assume, therefore, that they actually add nothing. So, on the basis, unlike Vedanta, that the Court of Appeal had hundreds of pages of internal Shell documents, it was able to reach its view on that basis, reach its evaluation, which it was for it to reach. And having seen the key documents, having seen the high watermark of the control frameworks, happening in a real life disclosure exercise, as happened in the Court of Appeal, one sees it gets nowhere. And as the Chancellor said at paragraph 178, we don't see how multiplying the production of the kind of material already referred to in Shell's HSEE framework would be likely to affect that outcome of the appeal. In short, the Court of Appeal had the appellant's point on further disclosure well in mind, examined it, but it didn't move the needle, and rightly so. Of course, it matters not, as I've said, and my lords don't need me to say this, but whether this court would have had a different view as to the significance of material said to create reasonable grounds. What I would respectfully say matters is that the Court of Appeal considered the point, carefully considered the point, made an assessment of it, and reached a conclusion. And the Chancellor, Lord Justice Simon, and indeed Mr. Justice Fraser, because he dealt with it too, clearly thought that it would make no difference to the appellant's case. I'll just make one footnote. The so-called Vedanta Route 4, on which it sounded as if Mr. Herman was putting more and more of his eggs into that basket, that doesn't depend upon internal documents at all. The whole point about Vedanta Route 4 is it depends on public documents. So they'd have those, they've got those. So further disclosure is not going to add to that at all. But viewing the probabilities, if the real question is, ultimately, when one looks at the circumstances in Nigeria, did RDS assume a responsibility for dealing with illegality, and bunkering, and sabotage in Nigeria? Prospects that RDS ever said it would do that are nil. It's not an operational failure for which more money or better expertise or management conviction can solve. It's a systemic problem that even the Nigerian government can't solve. In Vedanta, it was entirely within the parent company's control to fix the issue, and they said they'd done so, or were doing so. So the Court of Appeal found there was very little actual evidence to support the appellant's case. It considered the possibility that further disclosure would make a difference, reached an utterly reasonable conclusion and evaluation that it wouldn't. There's one further matter that Mr. Hermer has referred to in his argument, and he did this orally before you this morning. At the last minute, shortly before printed cases were due, the appellants wrote demanding that we disclose documents which were referenced in pleadings in proceedings in the Netherlands, on the basis that they might be relevant to the case. Now, we set out our full response. It's quite a detailed series of letters, and I respectfully invite my lords, my lady, to look at that. Our full response is set out at Appendix 2I, tab 111, page 3525, and Appendix 2I, tab 113, page 3560. But the real point, and Mr. Hermer refers to this, he talked about the business assurance letters and the fact that they had been at issue in the Dutch proceedings had been raised in the Court of Appeal. It had been raised in the Court of Appeal already. That can be seen at page 812 of the electronic bundle. It's misleading for the appellants to suggest this is somehow a new issue. And the nature and content of the business assurance letters was addressed in the courts below by both the appellants, that's at the electronic bundle, page 812, and our side, at page 859. The court took them into account when it found that disclosure would not change the conclusion on the issues in the appeal. This is yet another fishing expedition. This is yet another something might turn up. It's an elaborate form of McCorberism. And ultimately, the English courts cannot, we respectfully say, ask to exercise jurisdiction over a foreign defendant in respect to events alleged to have transpired entirely overseas on the speculative basis that something might turn up if the appellants are allowed to embark on a global fishing expedition for unspecified documents. Now, I'm not sure whether at the end of the day, my learned friend was making a point that he was complaining that the Court of Appeal had ultimately engaged in an impermissible mini-trial. But they didn't do that. What they did was engage in an evaluation of the evidence in order to determine whether there was an arguable case. And Mr. Justice Fraser asked himself, my lady have just seen this, whether the evidence taken at its highest showed that the appellants could succeed. Now, it's perfectly proper for the lower courts to consider the inherent probabilities of statements made by witnesses against the actual documents. I think it's Lord Justice Simon who says, what really matters is the documents. And they'd seen the documents that mattered. And of course, it would be to abdicate critical faculties simply to disregard the possibility that courts, experienced judges, can form an evaluation on what they've seen without cross-examination, without a full trial, in order to determine whether there's an arguable case. And that's what the Court of Appeal and Mr. Justice Fraser were doing. They weren't required to take everything at face value that the appellants asserted. They were entitled to give greater weight to the documents. They were entitled to see from the documents that actually they did not show what Mr. Hermer was advertising them for. When you analyze them, when you read them carefully, that's not what they're doing. I mean, I know it's always said, well, cross-examination may make a difference. Well, at the end of the day, and my lords, my lady will have ample experience of this, cross-examining witnesses about what documents say is something that counsel engage in all the time. We love doing it. Most of the time, it doesn't make any difference at all. It's what the court thinks the documents stand for matters. So it's not a case that cross-examination can be said to make any difference. I want to deal with two further points, or sets of points. I've mentioned access to justice. Oh, my Lord Briggs.
I just wanted to add one for you, Lord Goldsmith, in case you were up against the time limit. It's this. In the control framework document, you see that authority starts with the CEO, who I think has been at least arguably assumed to be a CEO of RDS, and ECHO,
yes,
committee, and is delegated down through the businesses,
yes,
to business executives, including no doubt that part of businesses vertically viewed, owned by individual subsidiaries.
yes,
And that reporting and audit works its way back up. But as with all delegation, accountability for the management of those businesses rests with the CEO and ExCo, which is a natural consequence of delegation. If this group was being run so that each business was regarded as the business of a separate subsidiary and managed and run by that subsidiary, would one not expect to see a structure under which the executives of that subsidiary reported up to that subsidiary's board on the basis of a delegation by each board to its executives, with accountability in that board stopping there and then being followed by reports up to shareholders, i.e. to parent companies?
Well, I think
it's part of the control question.
Can I take what I want? I want to actually take my lord to one passage in the control framework that I don't think you've seen. That's at document 55.
When you get there, I shall need an electronic page number.
Yeah, of course, and I'll give it to you when I get there. Sorry, I apologise.
I'm not suggesting that the individual boards of the subsidiaries have not authorised this structure, but what I'm talking about is the actual delegation of management responsibility and the retention of accountability, notwithstanding the delegation.
Yes, what I'm looking for, I think I've got the wrong document. If I can just what I'm helpfully being assisted with is that the accountability is for RDS for its own responsibilities, including under the Turnbull guidelines, under the requirements of the combined code. It has to demonstrate that it's put in place systems to deal with all these things, and that therefore these things do have to cascade back up to RDS. And that's what the control framework does. And I was actually looking for a reference which explains that the subsidiaries have their own boards and are responsible themselves. It's in one of the documents that I thought it's in the control framework. I'll give my lords the reference to it
Well,
when I get to it.
yes, I mean, don't let me, if you can pass up the reference to the pages at a later stage, that's perfectly all right for me, if it gets in the way of finishing on the other points that you want to deal with.
It's relevant to the point that Mr. Hermer was making about talking about the documents as statements by RDS. And what the documents make clear is that although the word "we" may be used, that is not a reference to RDS. That may be a reference actually to the subsidiaries, because they're the ones that do it. That's slightly different from the point I think my lord was making, that it's connected with it. And I had a reference to that, but we'll get it and come to it. My lords, so the access to justice. There are 2 points I want to underline. My lords and my lady will have seen from the judgment of Mr. Justice Fraser that he examined the question whether access to justice would not be possible in Nigeria, and strongly indicated his view that it could be. But we then, when it came to the Court of Appeal, therefore put in a respondent's notice. And if I can, I'll give my lords, my lady, the reference bundle page 669. The Court of Appeal was well aware of those issues because we'd put in a supplemental note. Now, what the Court of Appeal said was that they wouldn't decide that, but if they got to that stage, in other words, if Mr. Hermer had otherwise persuaded them, that matter would have to go back to Mr. Justice Fraser to determine, because he has to satisfy both limbs. So I'm just reminding my lords, my lady, that is an issue which isn't yet resolved. Obviously, that is also very relevant to the basis upon which Mr. Hermer says it's reasonable to be here in this country. And we do say access to justice is available in Nigeria. That's where these claimants should go. It's ironic that the reason given is because it would take too long in Nigeria if one considers the amount of time it's taken to get this case on here. And that was one of the points Mr. Justice Fraser made. It's hard to criticize other systems for delay. But as to the quality of justice, Mr. Justice Fraser was quite firmly of the view that that could be obtained in Nigeria. So it simply isn't the case, as Mr. Hermer's written papers start off with, that this case has to stay in England because otherwise these claimants will not get any justice. And it doesn't take account either of the fact that there are government plans to deal with the problems that exist in Nigeria. Let me therefore just recap, particularly given that some of the points I made before lunch may have been not heard. Point one, the Court of Appeal knew the question it had to answer, whether there was an arguable case on the evidence that RDS had taken over, intervened in, controlled, supervised, or advised the management of the relevant operations of SPDC. Their analysis of the evidence, as revealed by the judgments, makes abundantly clear that they applied a legal framework entirely consistent with Lord Briggs's formulation on control and intervention. The case put to the Court of Appeal by Mr. Hermer was that RDS exercised a high level of control. As I've said, he references this control in no fewer than 68 places in his skeleton for the Court of Appeal. That was the proposition he was trying to persuade the Court of Appeal on. He failed. We cannot criticize them for analyzing the very hypothesis of control that he put to them. Thirdly, the Court of Appeal looked very carefully at a vast array of documents. The Court of Appeal had more material available to it in this case than was the case in Vedanta. They can't be criticized for scrutinizing the very material that was urged upon. Indeed, the Court of Appeal have seen the key documents, apparently, the control framework, the specific technical standard, the DEP, applicable throughout the group to pipeline integrity, which Mr. Hermer chose not even to show you. None reveal that level of control or intervention articulated by my Lord Briggs, still less the provision of negligent advice that the appellants now speculate has been given. And even that most granular of the so-called mandatory guidelines say little more than the risk should be managed by having a plan. It's for SPDC to establish that plan, and it's SPDC who is responsible for that plan and its operations. So, my lords, having reviewed those key documents and the copious additional public domain documentation of witness evidence, it was unsurprising that the majority of the Court of Appeal concluded that there was no reasonably arguable case on control, and that further disclosure wouldn't change that conclusion. It's right to say that the Court of Appeal did use the lens of proximity, which was a framework urged on them by the appellants. While Lord Justice Simon talks about proximity, he could just as easily have said evidence of control, which is what he deals with. And so, because the courts below effectively address the questions of control and intervention, there's been no error of law and no basis for intervention. And may I respectfully submit that the same result needs to follow here to avoid confusion and inconsistency. The Court of Appeal adopted the same approach to the alleged duty of care that was taken by the Court of Appeal in Vedanta, a case in which the Court of Appeal's decision was subsequently upheld by this court. So no error of law, no error of approach. And given concurrent findings, this court should very respectfully, I submit, exercise particular caution. Can I give my lords the key evidence of our witnesses that I would respectfully, tentatively, ask my lords and my lady to consider? Mr. Akunbo, first witness statement, Appendix 2C, tab 32, electronic page 1619. He's the SPDC Managing Director, and he makes clear that SPDC is a fully independent company with its own assets, its own management. All relevant expertise resides with it. It doesn't rely upon RDS. His second witness statement, which is Appendix 2C, tab 32, electronic bundle page 1619.
I think that's the same number as you've already given us for the first witness statement. 169.
I'll correct that in a moment. But he explains in that witness statement there's no special relationship between RDS and SPDC. Mere assertion by appellants. No interference by RDS in SPDC operations. No reliance by SPDC on authorized technical expertise. No intervention by RDS in oil spill remediation. No intervention by RDS in JV operations. Mr. Agnetti, I've mentioned before, he's at 2D, tab 45. He's the head of pipeline integrity, and he makes clear that SPDC has all the technical and practical expertise on pipelines. He explains the implementation of group policies in Nigeria. He explains that they've tried concrete slabs and they've considered fiber optics, and they don't work. Mr. Andy Lee, I've referred to him too, Appendix 2I, tab 116. He's the remediation and oil spill response manager, explains oil spill response at SPDC. He explains the extent of sabotage, bunkering and illegal refining, and there's no reliance on RDS. Michael Branges, witness statement 2C, tab 33, electronic bundle page 1657. He's the company secretary of RDS, and he explains RDS's role, that it doesn't intervene in the operations of subsidiaries, it can't intervene in operations, and explains corporate governance within the group. His second witness statement is at 2D, tab 43, that's electronic bundle page 2025, and he explains more about the management structure, including the executive committee. It doesn't interfere in the affairs of the operating subsidiaries, doesn't take any decisions on their behalf. Explains auditing, explains the manuals, explains group audit, all of those things. My lords, my lady will find the answers that we say to the questions that we made. The Akunbo second statement should be page 2051, and I apologize for the wrong readings.
Thank you.
My lords, my final comment, subject to any question that my lords, my lady want to put to me, is we say, and we respectfully believe that my lords, my lady will find this when they examine it, all of our oral evidence is actually consistent with the documents. high-level guidance, no more, not taking control, not intervening, not doing those things which otherwise might give rise to an argument. We'll get, my lords, we'll get back to the court. I do apologise for this, for the reference I've got it somewhere in my notes to answer the question my lord Hicks put. But unless there are any other questions, or any questions that my lords, my lady want to put to me, those are our submissions for invitation to dismiss the appeal.
May I raise with you one point that I would have raised this morning, but given the difficulties we were having with technological problems, I didn't want to put you off your stride, Lord Goldsmith, and that is this. I wanted to bring to your attention the requirement in this court, where in our practice direction it said the case should not, without the permission of the court, exceed 50 pages of an A4 size, and in most cases fewer than 50 pages will be sufficient. In this case, the appellants applied for permission to the court and were given permission to produce a case that was of greater length. I don't think we received an application from you, and I would ask that those who are instructing you and those who are working with you will bear in mind in future cases this requirement.
Lord, absolutely. Though I'm slightly taken aback because I thought we had, because I was conscious of this, and I thought we had sent an application.
Well, if it did, it didn't come to me anyway. But as long as I don't think I need to set an investigation afoot, as long as everyone is alive to that requirement in a future case.
Lord, absolutely.
Thank you very much. Mr. Hermer.
Thank you, my lords and my lady. With greatest respect to Lord Goldsmith, the submissions that you have just received are the type of submissions that one might expect at the conclusion of a trial on the evidence, but not on an appeal. Almost every assertion made by my learned friend is in dispute. And it's not just in dispute because we put them to proof or because we say it's in dispute. It's in dispute because in respect of almost every assertion made, there is either evidence that is capable of doubting the case of Advance by Shell and SPDC, or putting it in a legally relevant different light. The core point and the starting point is whether or not the Court of Appeal made errors of law, and Lord Goldsmith has spent very little time assisting my lords and my lady on that. I'm going to come to that if I may, but it's helpful to set out the analytical framework if I've demonstrated that that's the case. Once one has the correct legal framework in mind, once one has Vedanta in mind, the questions are, is there a real dispute as to whether RDC could have intervened in the acts of SPDC? Then is there a dispute as to whether or not it did intervene in a legally relevant way? And finally, can these disputes, if they exist, be resolved without the need for trial or to disclose a single document? Can I keep that framework in mind and just deal in turn with some of the points made by my learned friend? And could I start with his, right at the very beginning of his submissions, with his characterization of the claim? As Lord Goldsmith sought to urge on you that the appropriate place for these claims is the Court of Nigeria, where he said it could be fairly dealt with, and because that's the right place for it to be determined. My lords, my lady, can I just make a number of very short points in response? Firstly, that's not the test. That's not the issue before the court. The issue before the court is the focused issue on the test in the law of England and Wales as to the existence of a duty of care and what the test is. Doesn't help. It's merely prejudicial, but in any event misplaced. There is a very real issue between the parties as to whether or not the claimants could get justice in the Court of Nigeria. At footnote 2 of our printed case, 215, you'll see some citations from the relevant judgment of Lord Justice Christopher Clark, in which, in the very starkest of terms, he describes the great difficulties in obtaining access to justice in Nigeria. We would also take very significant dispute with the way that Lord Goldsmith seeks to characterise the nature of the claims as all being the fault of the criminal acts of third parties. Now, that is, of course, a very significant problem. Not only do we not shy away from it, it's actually part of our case on security, which is the failure to properly deal with it. But it would be on our case, which this court, I accept, can't possibly resolve at this hearing, on our case, a gross mischaracterization of the causes of the devastation in the Niger Delta, to say that this is all the result of third-party intervention. On our case, it is in very large part because of what we would characterize, correctly or otherwise, as a callous disregard by the Shell Group for their own infrastructure, crumbling, chronic leaks, and a callous disregard for their responsibilities to clean up and remediate. Now, that is obviously how I put it on behalf of the claimants. And as I say, I don't submit for one moment the court can make any findings at this stage on that. But equally, the court should be very clear, very careful before accepting Lord Goldsmith's characterization of the problem, let alone before one seeks to kind of contextualize it in the history of the Biafran War or otherwise. A perhaps more neutral explanation can be found in the executive summary of the UNEP report. If I can just give you the reference of that, it's volume 2G, tab 90, page 2938. Could I deal with next with Lord Goldsmith's submissions on the evidential assessment? Because we say there is a danger that the court could have come away with the impression that there has been significant disclosure by RDS or SPDC, and indeed could come away with the impression that they've disclosed all the DEPs, the depths. I'm going to deal with each of the documents briefly in turn, if I may, but a little care over 30 witness statements that Lord Goldsmith told you about. Very many of those go to the question of access to justice. They're not all focused on the question of duty of care. The first document, although Lord Goldsmith didn't take you to it, is the control framework, the RDS control framework document, which my learned friend described as critical. That's a very telling comment for a document that neither Mr. Brandeis or Mr. Ockenberg refer to, not only refer to it at all, its existence at all, but as I said in my opening submissions, the very substance of their witness statements, which is a description of the nature of the two companies and the relationship between them, is almost impossible to reconcile with the contents of the control framework that Lord Goldsmith now accepts as critical, and which in his printed case he refers to as the Constitution. Next is the HSSE control framework, and Lord Goldsmith's submissions are that this doesn't really set out mandatory obligations. That's a submission that we say is irreconcilable with the findings of Lord Justice Simon and his description of the document. Perhaps the court be so kind as to go to the judgment at EF 472. This sets out in paragraph 101, it talks about the new business, which is P&T, governed amongst all other things, all relevant aspects of pipeline integrity and leak detection, down to the detail of wells that had to be used. It was headed by a member of EXCO, and to serve all of Shell's businesses. It was required to comply with the DEPs, which also form part of the HSSE framework. This is at paragraph 102. There's then a section from the DEP on pipeline integrity. I'm going to return to that in a moment. And then his lordship said this: despite the indication in the last paragraph that adopting the DEP was optional, it is clear that process safety requirements were mandatory, and then a paragraph from that DEP is set out. And then if my lords and my lady would just go to the bottom of 106, 2 lines below C, the HSSE control framework revealed the existence, although not the content, of a large number of mandatory technical practices. Now, for reasons that would have been obvious to Lord Goldsmith, but with the greatest respect not clear to us, the 2 documents within the control framework that he chose to take you to make good his points, ones that on their face would appear to have absolutely no relevance to the operations in dispute in this case. The first was on cleaning tanks, clearing tanks, and the second at 3396 on maritime safety to do with berthing of ships. Nothing whatsoever to do with the operations relevant to this case. And when the court has an opportunity to review just the 3 examples that I gave of documents in this case on process safety, on response to emergencies, and on security, one will see that it is imposing, there are 2 things that one will see. It is imposing detailed requirements, both at the top and all the way down through the organisation. And it is also referring to either other organisations within the Shell Group who appear to have a controlling and central role, or to other documents that appear to be relevant, none of which have been disclosed, or the identity, for example, of the centralised security or the centralised oil spill response. We know nothing about that. Nothing about who those organisations are, where they fit within the Shell Group, let alone the next level of documents about what they had to do, if anything, with the relevant spills, emails back and forth between the various entities. None of that is known. But what the framework does show is that which Lord Justice Simon and Lord Justice Sales described, which is a whole set of mandatory policies covering very many of the relevant aspects of the operations. And that is clear when one looks at the DEPs. And I wonder if we could just go again to the list of DEPs, which is in tab 70 of volume 2F at EF 2679. And can I just make, so the court's absolutely clear, the only DEP that was before the Court of Appeal was the one that Lord Goldsmith took you to on pipeline integrity. And the only other DEP was this document, which is simply the index. That's it. So when Lord Goldsmith is making submissions to you that we had everything down to the last granular detail, that is not correct. We had one. And a quick review of this document that I've taken you to show that there are a wealth of relevant DEPs. But DEPs, and I wish to stress this, are just, it is fair to assume, simply one class of document relevant to both showing whether the parent had the ability to intervene and whether it did in fact intervene, and what the nature of the intervention might be. There are also instructions, and we see the existence, we see the existence of instructions and standards if we go back to the pipeline DEP at tab 68, and if one looks at page 2668, which is right at the end, this is the standards, this is the DEP on pipeline integrity, the only one before the Court of Appeal. 2668, you'll see in the bibliography, it lists Shell standards, analysis of spans for submerged pipelines, etc. These are all standards, technical integrity framework. We don't have any of these, let alone what may well turn out to be the essential next layer of documents, which is how in reality these were applied or not applied, which is probably in the large going to consist, as Lord Bingham noted in Lebay, when we see the communications between the two parties. But what this undoubtedly shows is two things. Firstly, the ability of the parent to intervene through mandatory policies that it has imposed. And secondly, it highlights the fact that we're going to need to have disclosure of very many documents in order to fairly ascertain whether they did intervene and the nature of that intervention, and whether it is ultimately sufficient to establish at trial an arguable case. Could I deal very briefly with Vedanta and Lord Goldsmith's submissions that in fact in Vedanta there was evidence that was more granular, more detailed, and simply make 2 points. The one is simply to ask the court, as I did at the outset, to read the witness statements that we put in these cases: Sticko, Briggs, Sedgwick, and Siegel. And again, I don't wish to make any form of jury point, but to contend we would respectfully submit that that reflects less granularity or less detail about how the Nigerian subsidiary is dealt with by its parent is essentially Swiftian, to argue that black is white and white is black. And that, we say, jumps off the page if one reads those witness statements. The second point I wish to make about that is that Lord Goldsmith sought by reference to Vedanta itself to say that the materials before the court were considered by the court to be more persuasive, or to be particularly persuasive. He took you to the witness statement of the subsidiary's employee, and he took you to the agreement between the two parties. But as I noted in opening, at paragraph 61, 4087 of my Lord Briggs's judgment, my Lord was less impressed by those documents, and his conclusion as to the well-arguability of the claimant's case was based on the pleadings and the materials contained within the pleadings. Could I, just for your note, deal with one point in which Lord Goldsmith, by reference to the transcript, sought to assert that I had, on behalf of the claimants, admitted that there was no case for defective policies. My lord, my lady, you can just see that the relevant passages are in fact set out in my learned friend's printed case, see EF 329, in which I hope a fair reading of the answer I gave Lord Justice Sales is entirely consistent with the answer I gave my Lord Hodge this morning. My learned friends placed some reliance upon the evidential evaluation conducted by the first instance judge, Mr. Justice Fraser. With the greatest respect to the judge, it would be wrong to place any reliance upon his evidential evaluations. All three members of the court below concluded that his judgment was vitiated because of three errors of law. Firstly, that the acts and omissions of EXCO could not be attributed to RDS. Secondly, that nothing before a reorganisation in 2005 could be attributed to RDS, notwithstanding agreement that the reorganisation actually increased central control. And thirdly, that no reliance could be placed on RDS documents because there was a disclaimer on the first page that it couldn't be taken as expressing the views of the group. But those were all such fundamental errors that the Court of Appeal carried out their own analysis of the evidence. So it would be wrong, we respectfully submit, to seek to gain anything from that evidential analysis, because the approach of the learned judge to the evidence was again through the prism of the wrong test. And we would say exactly the same point in respect of the Court of Appeal, which takes me to the errors of law and global policy which together with disclosure were the only two that really Lord Goldsmith addressed, albeit very briefly. To be clear, our argument is not that at this stage the global policies prove a duty. I'm not coming to seek summary judgment. What we are saying is that they are capable of demonstrating an arguable duty. What the Court of Appeal said is no, they are not. And that is why they characterised the evidence of the witnesses in the way that they did. And it was, as Lord Justice Simon said, crucial to his reasoning. And that is a view of the result of the Court of Appeal, the judgment of the Court of Appeal, that is the one that all commentators have taken, be it interveners, Clark and Lindsall, or the New Zealand Court of Appeal. And it is plainly irreconcilable with Vedanta. Finally, on disclosure, and simply make one small point, if I may, in respect of the Dutch proceedings and what's being, and for the purpose on which we've asked you to look at them. It's absolutely not a fishing exercise being conducted in the hope that something might turn up. The Dutch Court of Appeal ordered disclosure of 4 classes of documents, none of which we have seen, because they considered them relevant to the issue of duty of care. Now, my point is that as a matter of fact demonstrates that there are relevant documents yet to be disclosed that bear upon the issues in this case. That cannot be fairly described as a fishing expedition launched in the hope that something might turn up. Taken together with all my other submissions, both on disclosure and on the duty more generally, and unless I can assist my lords or my lady in any other way, those are my submissions in reply.
Mr. Homer, thank you very much.
Okay.
Lord Goldsmith, I can confirm I've received a message from the court registry that we did receive a letter from you in early June. I think for some reason it may not have reached me, or if it did, I didn't spot it. So no allegation that the letter wasn't sent, but I would indicate to both parties that it is likely that the court will take quite a strict line in future, as we have in other cases, on the limit, and require a very reasoned explanation as to why that limit should be exceeded. The reason I allowed some flexibility in this case was because our decision to take a stronger line on the point was only adopted shortly before this case, and I thought it was unfair on the parties to take a strict line in those circumstances. But I just wish to put a marker down for future reference. Lord Briggs.
Can I just say I'm still looking forward to Lord Goldsmith's bundle references to the role of the subsidiary board.
Yes.
Not now, but by some appropriate route, reasonably soon.
If they could be emailed into the registry, that would be very helpful.
Thank you.
Yeah.
I'm so sorry. I'm so sorry to, having said I'd finished, but I was in fact going to make sure that my Lord Briggs had our answer to that, where you'll find the relevant points on delegation, if I may, with my Lord's permission.
Very briefly, because you have hit your time limit.
I'm so sorry. Then it's control framework again. I took you to one passage at 2253, but you will, if my Lord and my Lady be so kind to read the entire page, which includes a line that organisational approval, as a general rule, precedes corporate approval when it talks about the organisation of the group. So that's on that page, dealing with delegation. And I should add, we know nothing about the controller in charge of delegation of authority. We've had no.
Mr. Homer, no extra points, please, at this stage. You asked permission to give Lord Briggs a reference. That's as far as it goes.
Yeah,
thank you. I'll say no more.
Thank you. It was the one I had in mind. Thank you very much.
Well, the court is very grateful to counsel for their clear submissions and also to those who have assisted counsel in the preparation of their cases. We will take time to consider the submissions and will produce a judgment in due course. The court will now adjourn. Thank you.